So this is what... I haven't finished reading the book yet, the Erskine May book, but this is from my own brief assessment, and I don't think people kind of understand or frame it this way in their mind, but this is essentially, I think, what the gist of it is going to be, and that is that, if you start off probably with the 1100 Charter of Liberties, because in that Charter of Liberties, they agree that all of the barons and lords are going to be treated in law, answerable to the law, equally. So if they break the law, they've got to answer it and stand for their crimes, like anyone else, through the courts. I don't think that went too well for the Normans. Well, the Normans were the main barons because a lot of Anglo-Saxons were dispossessed of the land, so there weren't that many Anglo-Saxon barons left, really, or landowners, because the Normans took it all. But they upheld that law, which was inherited from Edward the Confessor, I think. So when we get to 1215 from 1100, so that's another 115 years, the barons are making the king sign this Magna Carta. Now, but everyone says, oh, the barons wanted to force the king to, uphold all these laws and rights and so forth, as if it's some sort of Magna Carta as, Oxford University and the whole kind of constitution, or the first proper constitution, or proper laws, which is actually not true. Because they got the Charter of Liberties and they've got all these laws of Edward the Confessor, and the traditions and customs. It's the traditions and customs which they held. All the people held these customs, right? The ancient customs. So the whole kind of honour and order was actually in these ancient customs. And I don't know why, but whenever you get David Cameron or Boris Johnson or anyone like that on television, any Oxford, they're always going to have this Magna Carta, but now it turns out that it's just, it is the Great Charter, but it's the Great Charter based on a previous charter, which is based on previous liberties and customs, right? That's why it's the Great Charter. It makes it the Great Charter because it's got all the liberties and the previous charters and the customs, the ancient customs in it. Now, the thing with Magna Carta is, one of the reasons the barons got John to sign the Magna Carta is that it gave them exclusive right for them to only be judged by their equals, right? The so-called privilege, and not accountable to everyone else equally, how it was meant to be from the Charter of Liberties. So really the baron, the king, really, I don't think the barons were like, oh, we want the land and the kingdom to be, fair and equal for everyone. They wanted their privilege. So they get the privilege. So from 1215 and all the way through, they keep messing around with Magna Carta, but they end up keeping it. So, and then it's not till 1688, so that's, like 400 odd years or whatever. Then we've got the Civil War, which, Charles wasn't happy about that. And then he curbs back on the petitioning rights with the Tumultuous Act, which is quite important, Public Act 13. And then we go on a bit after that and then you got that William Penn. All that William Penn stuff happens after the Civil War, 1640s and 1670s, and then it's in the William Penn time actually when the Bill of Rights is written, and they're also colonising America and experimenting with new constitutions over in America before America gets its independence. All these different English colonies are kind of experimenting with different laws and constitutions over there. But what so now, if you read Peter Ackroyd, The Histories of England, Volume 3, which is the volume that I read, which actually covers the Civil War period and leading up to it and just after it, when Cromwell and John Pym and so forth, when they had the short parliaments and long parliaments in the 1640s, they were in the Commons. They were all actually Cromwell and that assembly were all kind of like kind of talking about their privilege and demanding their privileges for Parliament, right? But if you think about it, this is like 1640s, before 1688. So it wasn't like a parliamentary privilege like the 1688 Bill of Rights, illegal prosecutions by the King's Bench for matters only cognizable, decidable, debatable in Parliament. That's not till way after. That's not till way after. That's not till another 40 odd years. But they were kind of like making this fuss about privilege when they were in the chamber. Now they didn't have any, because only lords and barons had the privilege, or not in the way that it's set out in the Bill of Rights. But they knew they had a type of privilege for petitioning the king, right? But this is before the Bill of Rights. But they've got that through, they've got it through petitioning the king. But you don't have the right to petition. But you got the Tumultuous Act. But they get it from being able to be judged only by their peers. So, but where does it come from? Well, that's what it comes from, being judged by your. The privilege comes from being judged by your peers. Usually, because I'm quite certain the basis of it is like the jury, and also the 100. You see, when someone else has done something wrong, everyone has to go catch them, so they get powers, right? When you're in pursuit of something officially, and I think that with what the thing is that they were wanting basically their privilege of being judged only by themselves in the Parliament, by each other, so that they were wanting their own kind of peerage in a way, but they didn't have it. But they were doing work. They knew they were doing work on behalf of the state, on behalf of the nation or whatever proper work. So they knew that they were engaged in casework, like you're engaged in casework if you're chasing criminals or if you're bringing a civil case or whatever. So I think, so therefore, when we get to 1688 and they've got this right to petition, and they write the right to petition, that Article 9 that Jeremy Johnson KC uses he focuses on it in his observations on behalf of the Lord's authorities, that paper that he writes. So when we've got all the dialogue from that Parliament as well with William Orange, the Act of Indemnity and so forth and all that. So the problem is that when it's not a problem. When they enact the illegal prosecutions clause, Article 9, that article is illegal prosecutions by the King's Bench for matters cognisable, decidable, debatable only in Parliament, right? But before that, there wasn't that clause. There was only the Magna Carta for the barons can only be judged by their equals. So there wasn't an official law really for the parliamentarians, the commons, to be only judged by over the other House of Commons people, because they weren't lords or barons, but they were engaged in casework. So what I think that they pushed that through and put that in with it, so it ended up that really is to make the House of Commons the MPs. So they've got a proper similar protection to the Lords, but it also adds to the Lords. So it actually, instead of being about the rank and the title and the position, it becomes a parliamentary privilege rather than just a peer privilege. So that's actually, I think, what happened then. And then after that, but they've still retained that they had to stand trial for their crimes. They've had that the whole time, that they've still got to stand trial. They're not immune from standing trial for crimes, but that means you've got to separate what is an offence and a crime and something done wrong, and then what is something that you're doing because it's in the line of duty. You're doing it because it's a requirement, and that's basically, it's the entire basis and model of the police, really, because it's the basis and model of a police officer breaking a door down when he's chasing someone, or a fireman cutting the roof off a car, or whatever. It's a difference between that and, say, like Lord Hindfield doing his expenses fraud or whatever, because it's not like in pursuit of a line of duty. It's going against what they're meant to be doing. Now, this would be, I mean, you might as well use a police officer model. I mean, if a police officer is taking money out of the police funds, and using it, to go on holiday with or whatever, then it's not in the line of duty chasing criminals, unless he's going on holiday, to investigate criminals like Madeleine McCann or whatever. But you see what I mean? But, who inquires into that? So, but the argument with Lord Hanningfield is that it's not anyone's business to even snoop in or inquire or question it. Whether it is or is not, or decide what is or what isn't. Whereas, really, it's meant to be clear what is and what isn't in the line of duty, and then you aren't punished for something that is required to be done in the line of duty, whereas you are punished for something that is not meant to be done in the line of duty. But what the argument that Johnson basically sets out in his paper is that it's not for anyone else to make a decision or decide. But that would mean the calculation and the math on that, or the way you work that out, though, would be that it would be that we wouldn't be able to actually accuse the Lords of crimes. We wouldn't even be able to make accusations against them. They could only make accusations against each other. But it's actually not. That's not the case. What the case is that from the Charter of Liberties, they had to, the Lords and Peers had to stand trial for their crime, right? Like anyone else. But after 1215, they can only be adjudged by their equals, by their peers. But that doesn't mean they can't be accused or investigated by anyone else. It just means that the judgment can only be, or the order or the judgment can only be from their equals. Otherwise, we wouldn't even be able to recognise or understand them doing anything wrong. That's almost like when you get right to the central core of the whole Palace of Westminster and the King now with the Privy Council oath, which is that the Privy Council oath makes that they cannot comprehend, understand, or even calculate or know anything that the King could possibly be done that is wrong, bad, or evil, or whatever. The Privy Council apparently can't even identify or know it. We don't take that oath. So they can't possibly take legal action against the monarch, even if we all might not know it, because they can't understand it anyway to make a judgment. But I'm quite certain that we can know and understand the Lords committing crime, and we can report it, and we can request action be taken, or them be judged by each other. I'm quite certain of that, because in the Charter of Liberties is the basis. When Magna Carta, those barons and clause, the barons and lords and their equals in Magna Carta, it doesn't stop us from being able to report them for their crimes. It just stops us from being able to sit as a jury, and so therefore, I do think that the parliamentarians, the MPs, do have privilege, but you definitely can. We're allowed to decide and identify what is and what isn't work for Parliament, but. And I think in the court you can actually establish that and come to a verdict, but they've got the privilege of protection. I think that I think the court is offering it up to Parliament. I think they're petitioning Parliament with their verdict, and then Parliament can act on it. But usually, if they're elected and they've got the privilege, then they can carry on doing their work or so forth. But they can be prosecuted in between sessions. It does make it clear, or make it a lot more common sense, in that Corrupt and Legal Practices Prevention Act, in those proceedings for the election petition. It makes more sense, but that might not be in agreement with Erskine May, and that's what I'm just about to read now. I've just started reading the opening part of it, the first part of it, and it seems that Erskine May is not actually telling the whole truth. So I'm going to finish scrutinising it and going through it. So really, the 1688 bill, therefore, was actually more for the parliamentarians. It was more for the House of Commons, the illegal prosecutions by the King's Bench, because the Lords didn't need it, the barons didn't need it. Queen Elizabeth repealed in 1967 most of those Magna Carta clauses, saying they were unnecessary. But if the 1688 Bill of Rights, illegal prosecutions, but that only it didn't stop any of them being accused of crimes or investigated for crimes, but it did give them the privilege of Parliament to carry on serving in Parliament and not go to prison. But it doesn't stop them being investigated, because otherwise you can't prevent corrupt and legal practices. That's why it's called the Corrupt and Legal Practices Prevention, because what you're doing is you're preventing corrupt and legal practices from continuing, and you're identifying them, and that's what the whole point is. Because if there's something wrong happening or something unlawful happening, then you need to stop it, don't you? You need to stop it from happening, or stop it from continuing. To get it looked at, to get it investigated, to find out exactly what is happening, and so forth. Parliament can vote to suspend its rules. So the rules don't apply, but if they don't vote to suspend the rules, and the rules haven't been suspended, and only they can suspend their rules, not people out of Parliament, but they can certainly criticise the rules for sure, or challenge them on them, that's for sure. So I'm actually starting to think now, So what I think the insight from that is, if you've missed it or if you haven't got the insight because you've been confused with what I've said, so the insight actually is that the Article 9 illegal prosecutions is more to do with the MPs and in the House of Commons rather than the House of Lords, but it applies to both. But the House of Lords didn't really need it. So really, that 1688 Bill of Rights was really a little bit more for the part for the House of Commons, the MPs, rather than all of Parliament. But and that's when they give us the right to petition indefinitely, clearly, very with great clarity. They give the right to petition for the citizens as well. It's quite different from Magna Carta, because what Magna Carta did, Magna Carta actually was, it had all the proper processes and procedures in it, and the ancient rights and liberties, but it was very much for the lords and the peers themselves. The elite class, whereas the 1688 Bill of Rights is more for the people and freedom of religion, rather than just for the elite classes. I think that's the difference of it, really, when it comes down to it.